follow me on Twitter at Jimbo Talks. And let's talk about getting back to work. A lot of people would certainly like to do that. And eventually, of course, we all will in one way or another. For some of us, it may not be really back, as in physically there. But for many of us, ultimately, it'll be just that. You're back, and there's the surrounding, the office, the factory, the workshop, whatever it is. And there you are. And danged if you don't get sick. And danged if you don't test positive for the virus. And you think you got it at work. Well, that could be time to talk to an attorney, like maybe Richard Bell, who's a civil rights attorney based in New York City. And Richard, thank you for joining us tonight.
Oh, thank you for having me, Jim.
Now, I understand that this is far from a hypothetical circumstance, that in fact I believe that there has been a legal victory for some McDonald's workers. Is that right?
Yes, Jim. Actually, this was both in Chicago and Oakland. And what happens was these McDonald workers were complaining to the employer they weren't getting the proper PPE and the proper social distancing wasn't being enforced. And they ended up as a group in Chicago and Oakland. They hired an attorney. They went to court. And they went on this fairly novel theory. It's called public nuisance. It's about 5 centuries old from Old England. But they used it in a novel way, and they basically said to the judges, look, there's an interference here with our right to health and safety because they're endangering us. So what the judge did in Chicago was she held this hearing for 4 days. She had everybody speak. She had medical testimony, manager testimony, worker testimony. And she said, McDonald's, you're doing a pretty good job, but pretty good isn't good enough in a pandemic. So you have to start, I'm ordering you to enforce the 6-foot social distancing. I'm ordering you to enforce the mask policy. And the judge in Oakland simply closed down McDonald's and said, you're closed down until you get that hearing because we have to get things done right here.
Now, I'm wondering how much of a precedent setter that is. I don't remember hearing a whole lot of cases that have gone quite that far in terms of enforcing employee health rights, if you will, on the job site. But then again, I don't read the ABA journal, so you tell me.
Well, here's the thing. You see, these are both trial-level cases. So trial-level state cases can go all over the place. They're really not precedent in the sense they haven't gone up on appeal, so we don't have an appellate decision on them. And as I said, it was kind of a novel use of what's called this public nuisance theory. So we have to see where the courts are going to go on this because a federal court back at the time that Smithfield, Missouri meat processing plant was having problems, the federal court said, we're not going to go to the public nuisance law on this one. I think this is a matter for OSHA. The only problem that happened with that is they said, we'll leave it to OSHA, and it's now 2 months later, and OSHA hasn't done very much.
Interesting. What does the law say currently about the whole notion? If I'm at work, let's say I work in a machine shop, okay, and darn it, I had to chop off the tip of my finger. Well, now, if it can be shown that I'm a pretty sloppy worker or I showed up drunk and I just was playing fast and loose with a piece of machinery, I would hope that I'm out of luck because no employer should be stuck with that. If, on the other hand, it can be shown that I was operating a piece of machinery that did not have what are the industry standard safety features, whatever, in my hypothetical example, then presumably I would have a case. Where do we stand right now as regards the law? And perhaps maybe it varies from state to state. I don't know.
Okay, generally, almost every state, I think the exception is Texas is the only state you don't have to have workers' comp law coverage in. But virtually every state, you have workers' compensation. So it's not a matter of fault in the workers' compensation system. If you're injured on the job and the injury was caused during the scope of your employment, then you can get lost wages and medical benefits with very few exceptions. Now the question becomes, what happens in COVID? What happens if, your example, machine shop guy goes there and he gets COVID? Well, you have to show that the COVID was caused from work. Now, there is a presumption, and certain states have a better presumption that the COVID did take place from a work activity. But the employer can come in and say, no, there's 92 other things you were doing in the last week. Why do you say you got it here? So that's going to be a big battleground in the months to come.
And that would seem fair, which leads us, I think, to the next question. Although you are an attorney and you deal in civil rights activity, but I would assume that you have a viewpoint as to how, in general, the law leans. Does the law, in general, lean enough in the protection of individuals, or does the law lean too much in the direction of protecting the companies?
Yes, so I am a liability attorney, and in the workers' comp sector, which I don't normally practice in, I practice more in the personal injury sector, but in workers' comp, there's definitely a leaning toward the worker, because that's the whole reason you can't sue your employer directly, is because we set up this whole workers' comp system to protect the workers. So the workers, for the most part, before these administrative judges get the benefit of the doubt. Now, there's this second aspect. If it's not your job that caused it, obviously, then you're in the court system, and that's the negligence law, and then that's going to be up to a jury. But in the work sector, the worker definitely is going to get the benefit of the doubt.
1-866-50-JIMBO is our number, 1-866-505-4626. Let's take a call from Doug in Avon, Minnesota, for our guest, civil rights attorney Richard Bell. Good evening, Doug.
Good evening. Quick question. My son wanted to buy a home from a private owner, selling it on his own. The owner wanted to have a public outdoor auction to get rid of some of his equipment and things before the sale of the home. And he spoke to his attorney, who told him that he would be liable if anybody came back 2, 3, 4 weeks later and said, we were at that public auction, there was no social distancing, no PPE, we caught the coronavirus there. Is there a possibility that they could even try to prove something like that?
Okay, Doug, interesting question, because it goes to what you would have to prove in a COVID negligence case. And here's what it is. Number one, you'd have to prove that there was negligence, not the proper PPE, not the proper social distancing, and that it wasn't reasonable for the person to have supervised that. But then you have to prove, Doug, more importantly, is that you got the COVID from that negligence. And that is a very, very high standard, because you have to rule out everything else. So your contact in a store, at work, at a neighbor. So these are going to be very, very difficult cases if anybody brings them.
Is that helpful to you, Doug?
Yes, but just more specifically, the gentleman is holding off selling the home because he was told by his attorney to wait until fall or next spring to even have the auction. That seems like a long way to wait for something like this when there's an unknown and nothing provable.
Yeah, well, then, Doug, you're now going to be involved in a contract or real estate situation. There's a whole different set of laws, and it's very fact-specific. So I don't want to give you advice that I just don't have enough information on.
Fair enough. All right, Doug, thanks for your call. And other calls welcome, of course, at 1-866-50-JIMBO, 1-866-505-4626. And we're talking with the civil rights attorney Richard Bell, and we're talking about the general notion, I suppose it applies beyond the pandemic, although that's the immediate application that people think about. But in general, what are your protections at the workplace? 1-866-50-JIMBO. We'll be back in just a moment.
Wash your hands, avoid sick people, and touching your face. There are everyday actions to help prevent the spread of respiratory diseases. Visit cdc.gov/COVID-19. Brought to you by the National Association of Broadcasters and this station.
1-866-50-JIMBO is our number, 1-866-505-4626. As we are talking tonight about the extent to which you are vulnerable, if you will, in the workplace by the law, and the extent to which you're protected. Attorney Richard Bell, our guest. The website is 877-CALL-LAW.com, 877-CALL-LAW.com. Here is Chris in Tyler, Texas. Hello, Chris.
Good evening.
Good
I have
evening.
a question for Mr. Bell
Uh-huh.
concerning the last caller. Is it possible in an auction situation like that to simply set a desk at the edge of the property and not allow anyone in that won't be willing to waive their right to sue the auctioneer or the property owner if they get COVID while they're there?
So you're saying, Chris, to physically set this at the end of the property to make space that people don't get within enough space? Is that what you're saying?
No. I'm saying just set up a desk and have a liability waiver there for them to sign.
Oh, okay.
Yeah,
Got it,
much like people signed when they attended that recent Trump rally.
Yes, very good question, Chris, the liability waivers, because it's something people should know about. So let's say you have a liability waiver. Obviously, it varies by state as to the viability of them. But here's the key on all of them. You can waive yourself out of what's called ordinary negligence, but not gross negligence. Almost no state's going to let a person or a business do that. And let me give you an example of what I'm talking about. So maybe if a waiver is held up in your state and it's ordinary negligence, like, you're not disinfecting enough times or you're not monitoring the social distancing as much as you should, maybe you can get out of liability. But gross negligence, like one of your employees has COVID or has symptoms and you let them interact with people, or you space things 2 feet apart instead of 6 feet apart, that you're not going to get out of. So you have to be very careful if you're a business who's producing these waivers. You need to know that you're not always getting out of it.
And as a follow-up to that, you're an attorney. Let's say I came to you, or Chris came to you with exactly what he's talking about. Could you draw up a waiver that you would consider to be probably pretty ironclad, that the person who offered that to people would be pretty safe?
The answer is no, because no waiver is ironclad, because it's not going to get you out of gross negligence. And even the ordinary negligence, you have to have certain typeset, interpret certain language. And even if all of that was good, a court could still invalidate it. So there's no such thing as ironclad in that.
Well, all right then. Let's go to Rich in Champaign, Illinois. Hi, Rich.
Hey, how you guys doing?
Fine, thank you.
Good.
I'd like to hear you guys talk about. I know you said that you didn't specialize in workers' compensation insurance, but I think the big issue is going to be if an employee comes down with COVID and gets a hold of an attorney and sues the employer. The bigger issue is, let's say that employee spreads it. Let's say it's a manufacturing employee with, thousands of employees, and a bunch of them get sick, and it causes a big dollar amount in claims. And the workers' compensation carrier pays for all the illnesses. Of course, right now a lot of people aren't getting very sick or need to have medical care. But if that happens, I think the big concern is if employers are going to be held responsible, what is that going to do to the renewal rates? Because it's always based on your claim activity. And going forward, I've been an insurance agent for 25 years, and it's all, renewal rates are based on your previous experience. But if they're going to pay for all this, the rates are going to skyrocket until there's a vaccine. I'd like to hear you guys discuss that if you have anything to say about it.
Okay. Go ahead, Richard.
Sure. So I guess, Rich, it would be the flip side to that. What would be your alternative? Not having comp coverage for the employees that have a COVID and it's clearly